Hey, good morning, guys. It is Chris with Nichols Retirement Empire outside here today. A beautiful day. It's a little cool down here in southeast Georgia. I'm doing a video today about how students get suspended from school. How does a student get suspended from school? There's been a lot of questions about that. I had a person a while back ask me to go through the process of how that works. And I'm a retired school administrator and teacher, and so I have a lot of direct experience about that, especially from the administration standpoint, because in general you'll find that teachers really don't know they just know that it happens. They don't know exactly the process and all that. So let's go through and let's discuss how that happens, because we'll see stuff in the news today and it'll be like, why was that student still in school? Why weren't they kicked out? Why weren't they, expelled and things like that? And so let's look at why people have all those questions now. All right, for one, students they're rarely expelled anymore. Expulsion is a permanent removal from school. You cannot go back once you are expelled. You can have an expulsion for a year, or you can have a permanent expulsion. Generally, when you say expulsion, it's permanent. So that rarely happens, and we'll talk about why here in a little bit. The general thing that you see are students that are suspended. Suspended is a temporary removal from school. All right, now, the way all this works is every school has a discipline code that is written down and is available to all students, all parents. It's public record. All right, the school discipline code. They get the school discipline code from the state laws. There are state laws that are written out. There was in Georgia, and I'm sure this is probably the case in every state, but there are state laws that are written out that pretty much spell out what schools can do and what the rules are governing student behavior and school discipline. So what we had at the district where I worked as an administrator is we had a discipline code that pretty much mirrored the state code, the state laws. And every student was issued the discipline code. It was made available to them. It was put in their hands. Usually we would put a physical copy in their hands. We had a copy online. It was very accessible where you could see this. Now, did people look at it? Very rarely. Very rarely. The only time they would look at it is if their child got in trouble and they needed to know what that code said and what the school could do and what the school couldn't do and why their child was in trouble and what was going to happen. And that was when they looked at it. They rarely looked at it before that. Now, so this code is made available to the public. The code spelled out exactly what the offenses were that students could commit. You had different levels of offenses, and the lesser offense, the lesser discipline that would occur, and the greater offense, the more discipline that could occur, the more serious discipline. Of course, now the bottom level offenses were just the general, run-of-the-mill little things, tardies, talking in class, just the stuff that the teachers don't want you doing, Now, the way that the code was written, if it was a level, let's say our level 3 offenses were the lowest offenses. The level 3 offenses had discipline results such as, it could just be a conference where the teacher would have a conference with a student, or the teacher would call the parent, or the administrator would have a conference with the student. The administrator would call the parent. There could be, low-level things like detentions, detentions from lunch, detentions after school, just small-level things, okay? Now, the next level of offenses, ours were level 2 offenses, and those offenses were more serious discipline code violations. For example, this might be where you've had repeated offenses, like you keep being tardy, you skip class, you maybe had an altercation, a verbal altercation with another student. You know, it could be all kind of things, but that's a little more serious level offenses. Now, those generally you would have discipline results such as in-school suspension. The student would be removed from class and put in school suspension, which was basically a room that we would have in the school or for the district or whatever. And different districts do it a different way. But anyway, the student would be taken away from their peers and out of their regular classes, placed in school suspension, where they would be allowed to do all their work. They would get all their stuff. If they needed help from a teacher could go see them during their planning period. Or, you know, we had an instructor. There had to be a certified teacher that was in there at all times. And then a lot of times you would have a paraprofessional, something like that would be in there. But generally you had to have a certified instructor in there at all times. So that's basically how that worked. And they couldn't, you know, it was a restricted environment. They couldn't talk to the other kids. They couldn't get up and, you know, like they took them to the bathroom all at the same time. You know, it was kind of like they were watched after all day. All right. So that's supposed to be the discipline for that level type of offense. They could be put in there from one day, you know, depending on what the offense was. Some of the offenses were, you know, 1 day. Some of the offenses were 3 days in ISS. Again, if you repeated offenses, the number of days went up. It was a progressive discipline type of idea. So all those things were handled for level 2 offenses. Now, level 1 offenses were the highest level offenses. Now, here you're going to start seeing things that if an adult did those offenses, it would be illegal. Okay, it could be things an adult may be charged for. If students got into a fight, that would be a level 1 offense. If students, you know, physically, you know, hit another student or shoved another student, the bullying offenses generally worked their way up. There was a level of bullying, like if you repeated it, it would go to level 2, and if you had so many offenses, it could go to level 1. You know, they would go up the line like that. But anyway, the way those things worked is if you got to that level, usually they were a lot of days in school suspension, like 5 to 10 days, stuff like that. Or they would be out of school suspensions. Now, this is where you start suspending a student out of school. Now, students, by law, have a right for a free and appropriate public education. Okay, it cannot be denied. They have to have a free and appropriate public education according to the federal government and our laws. And the state laws mirror the federal laws. So what happens is you could suspend a student out of school up to a number of days. It could be 10 days for a serious offense. Now, if you're going to deprive a student of their education past 10 days, what would happen is you would have to provide a free and appropriate education for those students. In other words, if a student did something serious, let's say a student brought drugs to school and we suspended him out of school for a whole semester, what would happen is we would have to give them an alternative to coming to school to get their free and appropriate public education. So what most schools do is they have some type of alternative school, and the student is allowed to go to the alternative school during the time that they are suspended out of school. They have to have instructors. They have to have access to, you know, if they're a special education student, they have to have access to all the different things that they are allowed as a special education student. Everything that they get in the regular school, they should get at the alternative school. Now, it is a more restrictive environment and all that kind of stuff in general, but basically they take them out of the regular school and into the alternative school. And that is generally what happens when students are suspended. They don't take away their free and appropriate public education. They don't take away their ability to go to school. They just change where they can go. If they get, again, if they're a special education student and they're supposed to get, you know, transportation back and forth to school, they take them to the alternative school instead of taking them to the, you know, to the regular school environment. And that's the way that generally works. Now, most school systems do not have an alternative school for elementary school students. They can only be suspended out for so many days by law. They can only, they have to be in school. So when elementary school students are having behaviors that are severe, that's a whole different issue. Either you have to have some kind of alternative situation for them in your school district, and you have to pay for it. If they have to have, like our school system had a whole school, had a building with teachers in it and all that kind of stuff. That was the alternative school, because we had a lot of high schools and a lot of middle schools. So all those students were sent there. If the student is basically 17 to 18, the way it was in Georgia, they could quit school if they wanted to without a parent's permission. But if a student was, in some cases, 16, 17, 18 years old, they did not have to attend the alternative school. They could choose not to. They could just choose not to go to school. And when their suspension was over, they could come back, that kind of thing. But anyway, that was the way it was that's the way it worked. All right, anytime that a student was suspended, the school had to go through a process, kind of like a trial and I don't mean a 10-day suspension, 10 days or less. I mean like a long-term suspension. The student would basically have to show up to a hearing. The hearing would have a group of people that would basically serve like as a jury. The school district would have a person that generally was kind of like, not really a judge, but a officer that would run the hearing. The school would present its evidence, and the way the evidence worked was all you had to have to prove your case as a school is a plurality of evidence. Okay, in other words, if over 50% of the evidence pointed to that student being guilty, that was enough. It's not a court of law. You're not, putting somebody in jail. You're not taking away their freedom. So the level of proof was lower than it is in a court, in a civil court. So the school would present their evidence. The student could present evidence if they wanted to, or the parents, or they could, whatever, they could present their case, that kind of thing. And then that body, usually it was 3 people, would decide whether or not this school was within its rights to suspend the student. We never took a student to a hearing that we weren't absolutely positive that we knew we were going to win because we had the evidence. I usually would shoot for, in those kind of cases, I didn't just want a plurality of evidence. I wanted to make it obvious and clear that that student had committed that offense with no questions, because we never wanted to lose a hearing. They could appeal that decision. The thing is, though, the student would still have to go through with the discipline. If they were suspended out of school, they were suspended out of school, and they could appeal it. And they could appeal it to the school board usually, and then the school board would listen to the hearing, and they would look at the evidence, and they would make a decision, and then you could appeal it to the state school board. I've never heard of any case that was ever overturned, because all you had to have was a plurality of evidence by state law. So that's the way that it works. And the reason, a lot of people are like, well, why aren't these kids kicked out when they stay in trouble over and over and over again? Because there's a process. The process is set up by the state. The process is set up by the government. You have to go through it. You can't just skip. You can't just go, man, this kid is terrible. We need to get him out of here. Let's kick him out now. You can't do that. You have to go through all the steps. You have to show all the evidence. You have to do all these things. And it's not an easy thing to do. You don't just go in there and sign a piece of paper and go, you're out of school, and kick them out. That's, no matter what, you can't do it that way. There's a legal process. So that's the way that works. That's how a student gets kicked out of school. A student is entitled to representation. They can get a lawyer if they want to. The lawyer can't do anything about the plurality of evidence situation. And usually if the student gets a lawyer, then the school district has a lawyer on retainer. And when you have the hearing, the lawyers pretty much run the hearing. And the district has the person that oversees it, and the lawyers can talk about it. And I've never seen that work either. The student can have any kind of representative. There are student, people that just basically represent students in situations like that. and they can come in and advise the parents on their rights and stuff like that. But generally, whatever the school does, because what the school does, they've done over and over and over again. They know exactly what they're doing. They know exactly how the process works. Most people that are lawyers are just going to tell you you're wasting your time. Unless the school did something procedurally wrong or the school did something illegal, there's not much you can do when your child gets suspended other than serve the suspension. Again, if you have any questions about that, just ask me. Thanks for watching, guys. Nichols Retirement Empire. Have a good day.